Our second presenter today is Professor Federico Lenzerini. Federico Lenzerini is a professor of international law, European Union law, and international human rights law at the Department of Political and International Science at the University of Siena in Italy. He is also a professor at the Master of Laws program in Intercultural Human Rights on the African System of Human Rights at St. Thomas University School of Law in Miami, Florida. He has been a visiting professor in several foreign universities and provided over 120 lectures in more than 20 countries. Professor Lenzerini is the deputy head of the Royal Commission of Inquiry. He will be presenting today on his article entitled Legal Opinion on the Authority of the Council of Regency of the Hawaiian Kingdom, published in Volume 3 of the Hawaiian Journal of Law and Politics, and also in the volume that you received today. Join me in welcoming Professor Federico Lenzerini.
Mahalo. You pronounce my name much better than most Italians do. Mahalo in particular to Keanu Sai. Now he's a good friend of mine, of course, for organizing this event. It's a real honor for me to be here, and it is an honor under many points of view. For instance, it is an honor to be associated to Professor Shebas. I mean, he's one of the most important authorities in international law, and in comparison to him, I am a student, so being in the same position in this event is really great for me. And before starting with my presentation, I have to say that I'm too close to the microphone. I have to say that, well, I was here already in 2017, 6 years ago, and it's a long way from Italy to get to Hawaii. Keanu knows that for Italians, Hawaii are a real myth, no? When we think about changing our life, and we think about going to Hawaii. And when I was here in 2017, I mean, I was here with my family. Only my oldest child was born. Now I'm here with 3 children, in addition to my wife. The youngest one is 2 months today, and he put his feet for the first time in the sea in Hawaii. And thank you, mahalo. And this morning, I mean, again, I repeat, it's a long way, but this morning when I saw many familiar faces again after 6 years, and it was about that no time had passed from last time. So it is like going back home in a way, coming here. This is the reason why I am very much honored, and I have also some sort of emotion in being here today. My relationship with the Hawaiian Kingdom at first was supposed to be only a professional relation. Now it is much more. And also under a professional point of view, I have to say that has been something very new for myself. I have been learning a lot in starting this exercise. In Italy, when it comes to international law, we have an idea of the law of occupation which is very, I would say, not dynamic. I would say static, in the sense that all Italian professors think that everything which happened before World War II cannot be put into discussion today. Irrespective of the events, of the circumstances, irrespective of the reasons which led a country to occupy another state, another independent state. And I have to confess that before meeting Professor Keanu Sai, I could not imagine what the real situation of Hawaii was. And in these years, I have learned a lot thanks to this involvement in your case. And so basically, today I have the possibility to say something, having reconsidered my knowledge and my learning of international law in light of the situation of the Hawaiian Kingdom. So basically, the purpose of my presentation is to assess the issue of the authority of the Council of Regency as a government of an occupied state. In addition, I had to assess also the authority of the Royal Commission of Inquiry, which is the main topic of the study that I have published in your review. And you know that the Royal Commission of Inquiry was established by the Council of Regency by proclamation in 2019. But before doing that, it is necessary to carry out a preliminary investigation concerning the basic question of the continuity of the Hawaiian Kingdom, which is exactly the key element of all our discussions. So let us start with this issue of the continuity of the Hawaiian Kingdom, because it is the preliminary aspect to be considered as a precondition even for imagining the possibility that there can be a legitimacy in the Council of Regency and the Royal Commission of Inquiry. So, the first question is whether the Hawaiian Kingdom can be considered today a state under international law, which is a very controversial question. As I previously told you, the answer to this question under the traditional approach which characterizes the School of International Law in the context of which I was formed would be negative. So it is certainly challenging under different points of view. And in view of providing an answer to the first question, it is also necessary to provide an answer to other two preliminary questions. The first one is whether there was a state at the time when it was militarily occupied by the United States in 1893, and then if the answer to this question can be considered positive, we had to assess whether the continuous occupation of Hawaii by the United States for 1893 to present times has led the Hawaiian Kingdom to be extinguished as an independent state. So, in other words, whether the Hawaiian Kingdom has ceased to be a state under international law as a consequence of the long-lasting American occupation. So, as regards the issue whether the Hawaiian Kingdom was a state at the time when it was occupied by the United States of America, I think that we don't need to spend much time on this issue because it was crystal clear that the Hawaiian Kingdom was an independent state at the time for a number of reasons. This was recognized in the Larson versus Hawaiian Kingdom case before the Permanent Court of Arbitration, that the Hawaiian Kingdom entertained many relations with other states and existed as an independent state. And also, under the theoretical point of view, it is quite clear that the kingdom fully satisfied the four elements of statehood that were considered at the time as essential in order to be an independent country, which were later codified by the Montevideo Convention on the Rights and Duties of States in 1933. That was a convention codifying pre-existing customary international law, which was already in force at the end of the 19th century. These elements are a permanent population, a defined territory, a government, and a capacity to enter into relations with the other states. As regards the latter aspect that I have cited, the Hawaiian Kingdom was a member of the Universal Postal Union since 1882. We had discussed this issue with both Professor Shebes and Keanu while we met at breakfast yesterday and this morning. And he had entered into extensive diplomatic and treaty relations with a number of states. Here you can find the list, probably the most important actors of the international community at the relevant time. And in light of what I have just said, the question to the first answer is certainly positive. In the 1890s, the Hawaiian Kingdom was a state and consequently a subject of international law. And this implied that its territorial sovereignty and its internal affairs could not be violated by other states under the rules in force at the relevant time in international law. So we have satisfied the first condition. It is essential to go forward with my presentation. The second question is whether the continuous occupation of Hawaii by the United States starting in 1893 has led the Hawaiian Kingdom to be extinguished as a state and as a subject of international law. And of course, the answer to this question is more controversial than the previous one, because you can imagine what is my position, of course, and I'm going to express it right now. But we had to recognize that several scholars in international law have a different idea. And I have experienced this especially in my own country. So it was not so good for me, because each time that I raise this issue at a conference, my Italian colleagues always give the same answer that I previously told you. No, what happened before World War II cannot be discussed any longer. It's now crystallized, and so international law has to respect all these situations. Probably, we were discussing this morning, the reason of this answer is not really because they think that the Hawaiian Kingdom is not a state, but because first, they don't know the reality about the Hawaiian Kingdom. And I had to confess that the same was for me before meeting Keanu. And second, the situation of the Hawaiian Kingdom is so unique that probably many scholars have never been considered how it should be settled under a legal point of view. In any event, we can say that many arguments could be raised in order to support one idea or another, and of course we don't have time at this point to list and to extensively discuss all these arguments. Here I have taken an excerpt from the case of the Larsen versus the Hawaiian Kingdom. And so we would need to consider a lot of elements in order to provide an answer to this question. But in any event, in my opinion, there is an argument which supersedes, which overcomes all the others. The fact that a rule of customary international law, long-lasting rule of customary international law exists according to which military occupation, irrespective of its temporal extension, cannot produce the effect of extinguishing the sovereignty and statehood of the occupied state. And now I have to say something that has already been anticipated by Professor Shebes. This is the issue of intertemporality, which is decisive in this discussion as well. This rule, of course, exists today, and it is universally recognized. What is important for us is whether or not it already existed at the time of the American occupation of the Hawaiian Kingdom. And this is exactly the issue of intertemporal law to which Professor Shebes referred in his presentation. So how can we demonstrate that this prohibition of taking the sovereignty of a state through military occupation already existed at the time when the Hawaiian Kingdom was occupied by the United States in 1893? We had to see to the relevant practice existing at that time. And already, well before the American occupation of the Hawaiian territory, at the Congress of Vienna, which, as you know, in a way transformed the system of international relations after the defeat of Napoleon, and especially, of course, in Europe, the delegations participating in the Congress endorsed the principle according to which when there was an instance of military occupation, the original sovereign of the territory retained its sovereignty. This sovereignty could not be overthrown by the occupying force. And by effect of this rule, all the states that had been occupied by Napoleon were considered as having retained their sovereignty. So the military occupation, even though gave rise to an effective exercise of sovereignty by the occupying power over the territory, was not considered sufficient to remove the original government from its sovereign powers. And I have mentioned the principle of effectiveness because this is probably the most important arguments which is used by those scholars that I was mentioning earlier to refute the idea that I'm trying to support in this presentation. Again, I come from a school in Italy. When we study international law at the university, normally we all study the same book in all Italian universities by a well-known Italian scholar known Benedetto Conforti. And according to him, sovereignty is determined by effectiveness. When there is an effective exercise of the government, there is sovereignty. Then, of course, there are some problems in this position with all due respect, because I'm talking about a legend of international law. I am just one of his students, of course. But with all due respect, there are some problems in this position because at the same time, yes, effectiveness is the rule. There are many exceptions because international practice demonstrates that in many instances, effectiveness is not enough to give rise to sovereignty, especially in time of military occupation. So, going back to the Congress of Vienna, the substance was that foreign occupation was considered illegitimate and the occupying power could not acquire legal sovereignty, the jure sovereignty, sovereignty by law. Here we have an excerpt in the original language, which is in French, from the Affaires de la dette publique ottomane, 1925, and it is a decision taken by the Swiss arbitrator Eugene Borel. 1925. This arbitrator reiterated that when there is a military occupation of a territory, in any event, this occupation cannot determine the acquisition of sovereignty by the occupying state. And of course, this arbitrator based his position on existing international law, on international law which was in force at the time. Okay, well before, no, well, not well before, but he referred that the judgment was subsequent to the American occupation of Hawaii. But he referred to a body of international law which existed well before the end of the 18th century. Of course, my presentation does not have the pretext of being exhaustive. I'm just reporting some examples. Here we have a presentation, more or less at the same time, 1928. This time is Judge Huber, and is the famous, of course, for the experts in the field the famous Island of Palmas arbitration. And according to this judge as well, belligerent occupation does not affect the continuity of the state. The government authorities may be driven into exile or silence, and the exercise of the powers of the state thereby affected. But it is settled that the powers themselves continue to exist. And it appears clear, even though it is not explicitly mentioned in this excerpt, that the temporal element is not decisive in this respect. And then this is quite paradoxical, in my opinion, because this is a doctrine which is often connected to the principle of ex injuria ius non oritur, which means that it is not legitimate to create law from violations. Violations cannot be the source of law. It's a famous doctrine elaborated in 1932 by the US Secretary of State, Henry Stimson. This is the reason why it is called the Stimson Doctrine. And the United States took a position about the situation that at the time was ongoing between Japan and China. And it was possible that some parts of the territory of China could be taken by Japan, and Japan could establish its sovereignty on some territories of China, either by agreement or through military occupation. And the US Secretary of State asserted that his government would never recognize any territorial change determined in this particular context. So his position was clear on the fact that military occupation could not determine any change in the sovereignty of a territory of a state. And it is paradoxical that this doctrine was elaborated more or less in between the occupation of Hawaii by the United States and the time when Hawaii was officially considered as a state of the US Federation. So we can see that objectively there is a lack of coherence in the behavior of this government towards the situation of military occupation. No, sorry. How can I go back? No, the previous one, please. Okay. And then we have also an excerpt from one of the decisions taken by the military tribunal at Nuremberg in 1948, previously mentioned, of course, by Professor Shebes, according to which in belligerent occupation, the occupying power does not hold enemy territory by virtue of any legal right. On the contrary, it merely exercises a precarious and temporary actual control. I reiterate, because this is the important aspect in my opinion, that all these positions taken by important authorities in the context of international law were based on a law which was pre-existing the occupation of the Hawaiian Kingdom by the United States of America. And then we come to some of the most important scholars, contemporary scholars in international law. Again, you know, sometimes when you are a professor, a university professor, your students tend to think that you know everything about what you are teaching them. This is not true. We have to learn day after day. For instance, I was mentioning the fact of being honored to be together with Professor Shebes, and this is confirmed by the fact that we had two occasions of being together for half an hour at breakfast yesterday and today, and I don't know how many things I learned from him in about 1 hour. And so we continue to learn day after day and day after day. And when I started after meeting Keanu to try to deepen my knowledge on this issue of military occupation in international law, I was somehow surprised by the fact that especially scholars of Anglo-Saxon origin had a totally different position from the one that I was used to hear in my School of International Law, which had been presented to me as the only possible solution. On the contrary, you see that, of course, these names are very well known among the experts of international law. I'm talking about real authorities, James Crawford, Ian Brownlee, Joran Dinstein, but these are just examples. And they state what I'm trying to further today. That is that there cannot be acquisition of sovereignty by an occupying country through military occupation. And this is a rule which still exists today, but was already valid. I apologize for repeating this argument many times, but it is central in our discussion. It is a rule which has not been affected by the passing of time. Just like the fact that military occupation cannot give rise to the acquisition of sovereignty by the occupying power is not affected by the passing of time. Because there are also some scholars of it saying that, okay, we can assert that the occupied state retains its sovereignty on the condition that this sovereignty does not last too much in time, because then when it is prolonged in time, we can presume that it is accepted by the international community, and so this acceptance turns the effective situation into law. Now, this cannot be supported. The length, the extension in time of the military occupation has absolutely no significance in this respect. And going back to the arbitration in the Affaire de la dette publique ottomane in 1925, the judge also made it clear that there is only one way to make it possible the sovereignty is transferred from the occupied to the occupying country, which is a treaty under international law. It's a treaty which must be valid, and so the occupied country must enter into this treaty without being forced to do that, so voluntarily. There must be an expression of consent by both parties to the extent that this consent gives rise to the transfer of sovereignty from a state to another. And again, this is reiterated by scholars as well. Oppenheim is another very renowned scholar of international law. He's the author of one of the historically most important textbooks of international law, and he took this position. And we have also to refute another theory according to which, hypothetically, a transfer of sovereignty would be possible by prescription on the condition that there is acquiescence by the occupied authorities or people. It is something very similar to, how can I say, inverse possession in private law, no? Which with the passing of time gives rise to the transfer of property. But even leaving aside that, of course, this idea is very controversial and could be discussed under several aspects. In any event, it is not of interest for us because the Hawaiian Kingdom or its people had never agreed to the occupation of the United States. And they had never accepted the transfer, the cession of sovereignty over their islands to the United States. And this is what I anticipated previously, no? That there cannot be transfer of sovereignty even when the military occupation lasts for a long time. History learns that the United States has taken possession of the territory of Hawaii through de facto occupation only, through effectual occupation only, and unilateral annexation without concluding any treaty with the Hawaiian Kingdom and without any questions by the Hawaiian people. This is another technical issue, and probably Keanu can explain this issue better than me, is a reference to the theory of estoppel, the rule of estoppel, by virtue of which, under international law, legitimate expectation of states induced by the conduct of another state are protected. You know, I'm sure better than me, then immediately after the American occupation, there was an agreement between Queen Lili Uokalani and President Cleveland, U.S. President Cleveland, in which the U.S. President took a commitment to return the sovereignty over the Hawaiian Islands to the Queen. And so this created an expectation in the Hawaiian people that then was not respected by the U.S. because in reality, this treaty was never put into effect because it was not backed by the Congress, and on the contrary, the United States decided to proceed to the annexation of the Hawaiian territory. So this is another reason supporting the idea that no transfer of sovereignty has occurred from the Hawaiian Kingdom to the United States. So, we have finally come to the conclusion regarding the first issue, very long. We can conclude that the Hawaiian Kingdom cannot be considered as extinguished as an independent state and as a subject of international law, despite the long and continuous occupation by the United States of America. Because there is this rule of international law according to which illegal occupation cannot of itself terminate statehood. This is the principle to which I was referring earlier. Ex injuria ius non oritur. I am Italian, so I am probably my spelling of Latin is different from yours. But I can say that since the Latin language originated in Italy, my pronunciation is the right one. No, of course, I'm joking, but I'm discussing all the time with a German colleague of mine. He is from Germany, but he teaches in the United States since a long time. And when we discuss about the pronunciation of certain Latin words, for instance, ius cogens or ius cogens, no? In Italy, we tend to say ius cogens, which means peremptory international law, imperative international law. In English, we used to say, and we discuss, and I say, I am Italian, so I know very well how Latin is to be pronounced. And he says, oh yes, you're Italian, but I am German, and we know that the most renowned experts in the study of Latin language are from German. So I am right. And we never come to an agreement on this point. But anyway, I was just explaining why my pronunciation of Latin can be different from the one to which I used, because we study Latin at the high school in Italy, and so we have this tendency to pronounce it in the Italian way. And the following conclusion is that it is not a conclusion, it's a confirmation of the conclusion that the possession of the attribute of statehood by the Hawaiian Kingdom was in substance confirmed by the Permanent Court of Arbitration in the Larsens versus the Hawaiian Kingdom, because, as Keanu will explain better than me, in order for a case to be admitted before the Permanent Court of Arbitration, you need to have at least one party, which is a state, unless it is an international organization. In the case of Larsen, there was a state against a private person. The private person was Larsen, the Hawaiian Kingdom was the state. Then the tribunal did not take a position on this issue because, for the reasons that we know very well, for the rule of the indispensable third party, so did not take a position on the substance of the case. But of course, the acceptance of the fact that the Hawaiian Kingdom is a state was necessary in order to start the case itself, to admit the case in front of the Permanent Court of Arbitration. Okay, I have to hurry up, I think. Okay, so the Hawaiian Kingdom is a state under international law, and this is my conclusion today. Yes, this point is important because this rule is a further confirmation. Professor Sheb has mentioned the Hague Conventions of 1899 and 1907. And there is a further confirmation of this position that military occupation cannot give rise to the transfer of sovereignty from the occupied territory to the occupying government, was codified in Article 42 of the regulations annexed to the Hague Convention 4th, respecting the laws and customs of war on land of 1907. And this was a convention codifying pre-existing customary international law. So again, it is a confirmation of the fact that already at the time of the American occupation of Hawaii, it is not possible to acquire sovereignty of a territory through military occupation only. And it was necessary to have a treaty. Okay, let's now move to the following issue. The authority of the Council of Regency as a government of an occupied state. A regency is the man or body of man entrusted with the vicarious government of a kingdom during the minority, absence, insanity, or other disability of the king. Of course, this list is does not cover all the possible situations in which it is necessary to have a regency. When it comes to the situation of the Hawaiian Kingdom, a regency is certainly the right body entitled to provisionally exercise the powers of the Hawaiian executive monarch in the absence of the latter, of the monarch itself, himself or herself. And this is an absence which forcibly continues today due to the persistent situation of occupation to which the Hawaiian Kingdom is subjected by the United States of America. In legal terms, the legitimacy of the Hawaiian Council of Regency is grounded on Articles 32 and 33 of the Hawaiian Kingdom Constitution of 1864. You have here the text of Article 32. Whenever upon the decease of the reigning sovereign, the heir shall be less than 18 years of age, the royal power shall be exercised by Regent Council of Regency, as hereinafter provided. And then we have the text of Article 33 as well, which confirms the legitimacy of the establishment of a regency to replace the monarch, the legitimate monarch. So the Council of Regency was established by proclamation in 1997 because there was the offices were vacant in the Cabinet Council on the basis of the doctrine of necessity, the application of which was justified by the absence of the king or the queen. So in the end, the Council of Regency possesses the constitutional authority to temporarily exercise the royal powers of the Hawaiian Kingdom. And this authority also exists under international law because the Council of Regency can be considered as serving as the provisional government of the Hawaiian Kingdom. And this is similar to the example of Belgium, which was referred to before this presentation. No? And should the military occupation come to an end, then the Council of Regency, of course, will convene the Legislative Assembly, and the Legislative Assembly will proceed to choose the king or the queen, the monarch of the Hawaiian Kingdom. So basically, the Council of Regency holds under both domestic and international law the authority to represent the Hawaiian Kingdom as a state. This conclusion is quite plain, and the reason why I'm devoting less time to this issue is exactly because it's not as controversial as it was the previous one. On the contrary, we need to devote a little bit more attention to the position concerning the Royal Commission of Inquiry. Here again, you have the conclusion according to which the Council of Regency is legitimate under international law and is in the same position of a government of a state under military occupation. Is vested with the rights and powers recognized to governments of occupied states pursuant to international humanitarian law. So, among these powers, in a way that is, of course, consistent with the powers exercised by the occupying government, the Council of Regency has the power to legislate, to defend the interest of the population of the Hawaiian Kingdom. So, to some extent, the Council of Regency may interact with the exercise of authority by the occupying powers. And this is a principle which is well recognized under international humanitarian law, that there should be in principle a cooperation between the two powers, and the government representing the occupied population can continue to legislate when this is necessary in order to protect the interest of the occupation itself. And of course, when this does not create a conflict with the exercise of the power by the occupying forces. And we can say that when it comes to the proclamation of the Royal Commission of Inquiry, there is absolutely, let me find the relevant slide. Okay. There is no absolutely conflict with the exercise of the powers by the occupying power, the United States. The Royal Commission of Inquiry was established by proclamation in 2019. In a similar fashion to the United States proposal of establishing a commission of inquiry after the end of the First World War to consider generally the culpability of the authors of the war and so on. So you see that what has been done here in the Hawaiian Kingdom reflects a practice that was already followed by the United States themselves. Again, this is my final point, we need to ascertain whether the establishment of the Royal Commission of Inquiry can be considered legitimate under international law. And the answer to this question is certainly positive, because as we may read in the proclamation establishing the Commission, its purpose shall be to investigate the consequences of the United States belligerent occupation, including with regard to international law, humanitarian law and human rights, and the allegations of war crimes committed in that context. The concept of the Royal Commission of Inquiry is therefore to ascertain whether violations of human rights and international humanitarian law have been committed to the prejudice of the Hawaiian population and also to other people being in Hawaii, not necessarily Hawaiian citizens, during the occupation itself, as a consequence of the military occupation. And as I was saying earlier, the proclamation of the Commission of Inquiry and also the carrying out of the role of the Commission of Inquiry in itself do in no way undermine the rights and interests of the civilian population. On the contrary, this Commission has the purpose to protect the rights and interests of the civilian population. So this is perfectly consistent with the law of occupation because it does not create any conflict with the exercise of authority by the United States as the occupying power. And on the contrary, it has the purpose to further the interest of the people residing in the Hawaiian Kingdom for the damages that they have suffered as a consequence of the occupation. And so this situation, these dynamics, is to be considered in the context of the relation between the occupying and the occupied power, in the sense that the proclamation of the Royal Commission of Inquiry and the exercise by the Commission of its competencies does not undermine or significantly interfere with the exercise of the authority of the occupying power and is consistent with international obligations in the field. So not only the United States is not prejudiced by the presence of the Commission and by the exercise by the Commission of its powers, but to some extent it should recognize the outcome of the exercise of these competencies because they have exactly the purpose of protecting the interest of the population with respect to which the United States has an obligation under international law to protect their rights and interests. So, in conclusion, the occupying power cannot be considered absolutely prevented from recognizing the legitimacy and from applying eventually the proclamation of the Council of Regency establishing the Royal Commission of Inquiry as a piece of domestic legislation protecting the human rights of the local population, and therefore has a duty to do that in the context of that duty of cooperating with the representative of the occupied people in order to protect the interest of the population living in the Hawaiian Islands. So in conclusion, the Royal Commission of Inquiry is legal under international law and has to play a role which in the future can also produce important outcomes should the occupation come to an end, because the decision taken by the Commission and all the outcomes of its activity could be applied to the Hawaiian Kingdom following the end of the American occupation. For this reason, I repeat that the United States of America not only should recognize the activity of the Royal Commission of Inquiry, but should also cooperate in making possible the application of the outcomes of this activity. Thank you very much.